The attorney smiled. It was the kind of smile that didn't start in the eyes. It was a professional tool, meant to signal the end of a transaction, the satisfactory closing of a file. He slid a thin folder across the polished mahogany of the conference room table. So, if you'll sign here and here, Mr. and Mrs. Gable, the property is officially yours. Keys will be delivered by 5 p.m. today. The young couple, the Gables, looked at each other with the nervous excitement of people making their first significant purchase. The room was quiet, conditioned air humming softly, the faint scent of coffee and paper hanging in the air. The bank had done its part. The foreclosure had been clean, the auction properly noticed, the sale finalized. Everything was in order. From the back of the room a voice spoke, calm and even, not loud, but carrying through the stillness. That house was never the bank's to sell. James Holt had been sitting in a chair against the wall unnoticed. He hadn't been invited, but he had walked in and sat down 10 minutes earlier, and no one had asked him to leave. He wore clean work boots, the leather creased and dark with age, and a blue cotton shirt, pressed but softened from 1,000 washings. He stood up and walked to the table. He was not a large man, but his movements were deliberate, economical. He placed a long cardboard tube on the table, its ends capped with plastic. It made a soft, solid sound against the wood. The attorney, whose name was Davies, looked up, his smile freezing and then dissolving. He didn't recognize the man. He saw the weathered hands, the dust on the cuffs of his jeans. He saw a problem. "Who are you?" he asked, his voice losing its warmth. "I'm Eleanor Holt's son. My father was Frank Holt." The name seemed to mean nothing to Davies. He glanced at the Gables, giving them a reassuring nod, the professional retrieving his composure. "Sir, I'm afraid this is a private meeting. The foreclosure on your mother's property was concluded 2 months ago. The auction was public. This is merely the final signing with the new owners. It's a procedural matter." James Holt looked at the attorney. He didn't look at the couple. He didn't look at the folder full of papers. His gaze was fixed on the man who ran the meeting. "I understand procedure," he said. He tapped the cardboard tube with a single finger. "But you started with the wrong set of facts." The room went quiet. The Gables looked from the attorney to James, their brief joy turning to confusion and anxiety. The wife put a hand on her husband's arm. The real estate agent sitting beside them cleared his throat and shifted in his chair, suddenly finding the grain of the mahogany table intensely interesting. Davies sighed, a performance of practiced patience. "Mr. Holt," he began, his tone now that of a man explaining a simple concept to a difficult child. "Your mother, Eleanor Holt, took out a home equity line of credit in 2008. She subsequently defaulted on payments connected to that account after the bank covered an outstanding property tax lien to protect its interest. We sent numerous notices. We followed the letter of the law. A judge reviewed the case and issued a final order of foreclosure. The property was sold at a legal public auction for $9,000 to cover the outstanding debt and fees. It is, I am sorry to say, over." He spoke the words as if they were solid objects, facts as hard and unyielding as the table they were all sitting at. He had done this dozens of times. He knew the script. He expected anger, tears, perhaps a threat. He did not expect the quiet certainty he saw in the other man's eyes. James Holt said nothing. He let the attorney's words settle in the silent room. He understood them perfectly. They were the same words he had read on the notices that had arrived at his mother's house, each one a paper hammer blow against her resolve. He had seen the legal notices published in the local paper, small blocks of text no one ever read. He knew the bank believed it was right. Institutions always believe they are right. It is the foundation of their existence. What everyone assumes is what no one verifies. The attorney, Davies, took the silence as a victory. He straightened his tie and offered another thin smile.
This one meant to be conciliatory. Look, I know this is difficult. The bank is not without sympathy. We can direct you to resources, perhaps arrange a conversation about a modest relocation stipend. He was already moving past the problem, managing the emotional fallout. James Holt looked at him. No stipend, he said. He slid the cardboard tube to the center of the table. He pulled off one of the plastic caps. The air inside smelled of old paper and cedar.
He carefully tipped the tube, and a tightly rolled document, yellowed with age, slid out. He unrolled it slowly. The paper was brittle, and it crackled in the quiet room. He placed his hands on it to hold it flat. The document was covered in elegant typed text from a machine 40 years old. The ink faded from black to a soft grey. There were signatures at the bottom, and a raised embossed seal from the county recorder's office. The new owners, the Gables, leaned forward slightly, trying to see. Their own paperwork, crisp and white and freshly printed, sat in its folder, suddenly looking flimsy and temporary. Davies glanced at the old document with dismissive curiosity. What is this? A will? Mr. Holt, a will would have gone through probate. It wouldn't supersede a secured lien against the property itself. He was confident, standing on the firm ground of established process. The bank's legal team had vetted the foreclosure. Their title search was exhaustive. A deed, James said. From 1979. Davies let out a short, humourless laugh. A 1979 deed? Sir, with all due respect, that is irrelevant. There have been numerous filings since then, most notably the 2008 mortgage instrument your mother signed. Subsequent filings take precedence. That's how real estate law works. It's a chain of title. The most recent link is the one that matters. He spoke with the absolute certainty of a man who had never been proven wrong in a room like this. He looked at James Holt as if he were a relic, a man bringing a stone tool to a modern negotiation. And he was right. That was how it usually worked. But Frank Holt had not been a usual man. He had been a meticulous man, a man who understood that the first link in a chain determines the strength of the whole thing. James didn't argue the point of law. He simply looked at the attorney and waited. The silence stretched. The humming of the air conditioner seemed to grow louder. Some men collect problems. He collected patience. To understand the cardboard tube, you have to go back 6 weeks. James was in his mother's kitchen. The final notice was on the table, a stark white paper with red lettering at the top. It said she had 72 hours to vacate the premises. Eleanor Holt was sitting in the chair her husband had always used, her hands trembling around a cold cup of tea. She was 78 years old. She had lived in this house for 51 years. Her husband, Frank, had built most of it with his own 2 hands. Now, a piece of paper was telling her it was no longer hers. "It's my fault," she whispered. "I shouldn't have taken that money." The money was for a heart procedure, a few years after Frank died. She hadn't wanted to bother James, had wanted to handle it herself. The home equity loan had seemed so simple at the time. The bank manager had been so kind. The debt had ballooned slowly, quietly, after a missed payment, then a property tax bill the bank paid from the escrow, adding fees and interest. It grew from a few thousand to $9,000. It was a small number to a bank. It was an impossible number for her. James sat with her for an hour. He didn't say much. He just refilled her tea and listened. When she finally went to lie down, he stayed at the kitchen table, looking at the notice. He felt a cold, quiet anger settle in his gut. It wasn't loud or hot. It was heavy. It was the anger of a builder seeing a good structure being torn down for a bad reason. That night, he went up to the attic. He wasn't looking for anything in particular. He was just connecting with the space, with his father's things. Frank had been gone for 15 years, but the attic was still his domain. There were boxes of old receipts neatly bundled with twine, blueprints for the house extension he'd built in '82, his old surveying tools in a long wooden box, and in the corner, Under a canvas tarp was a metal footlocker. James pried it open. Inside, nestled among his father's army discharge papers and the box of faded photographs, was the cardboard tube. He had seen it before, as a boy, but had never known what was inside. He took it downstairs. At the kitchen table, under the dim light, he unrolled the deed. He read it once, then twice. The language was dense, legal, but two phrases stood out to him. Quitclaim deed. And then the grantees, Frank Holt and Eleanor Holt, his wife, as tenants by the entirety. He didn't know what it meant, not then, but he knew his father. Frank Holt did nothing by accident. The next day he took the deed to the county library. He didn't use the internet. He went to the reference section and pulled out old, heavy books on state property law. He sat there for hours reading, taking notes in a small spiral notebook. He learned that a quitclaim deed transferred interest in a property, and he learned what tenancy by the entirety meant. It was a special kind of ownership, available only to married couples. It treated the couple as a single legal entity. One could not sell or mortgage the property without the other, and when one spouse died, the other inherited the entire property automatically, outside of probate, free and clear of the deceased spouse's individual creditors. The property was a whole thing. It couldn't be broken. He read it 3 times. The house was a whole thing. Frank Holt had been a surveyor's assistant for the county for 40 years. His world was one of lines, degrees, and boundaries. He believed in the quiet authority of a properly recorded document. He believed that a line drawn in the right place and filed in the right way could last for 100 years. He had taught James how to read a plat map when he was just a boy, how to find the iron pins that mark the corners of a property hidden in the tall grass. Measure twice, cut once, he'd say, tapping the blueprint with his finger.
It wasn't just about wood. It was about everything. Do the work up front. Check your corners. Don't assume. The house stood on a piece of land that had been in his family for generations. He and his brother had framed it themselves in the summer of 1972, the year before James was born. It was a simple, solid house with good bones and a roofline that was perfectly straight. In 1979, Frank had a health scare, a minor heart attack that put him in the hospital for a week. It scared him, not the dying part, but the leaving things messy part. When he got out, the first thing he did was go to a lawyer. He had the original deed, which was just in his name, redrawn. He explained it to Eleanor one evening at the kitchen table, the new deed spread out between them. This here, he said, pointing to the words, tenants by the entirety. This means the house isn't mine or yours. It's ours. It's one thing. If I die, it all goes to you. No questions asked, no courts. No one can touch it for any debt that's just mine. And vice versa. It makes the house safe. Eleanor had nodded, trusting him completely. She signed where he told her to sign. They filed it at the courthouse the next day. The clerk stamped it with a satisfying thud, and then they put it in the tube in the footlocker, and for 40 years, they forgot about it. When Frank died in 2005, that deed did its silent work. Ownership transferred to Eleanor seamlessly, automatically. The house was hers. But the memory of that conversation, of those specific words, had faded. So when the bank manager in 2008 offered her the home equity loan, she signed the papers. She was the owner, after all. The bank's title company did a search. They saw the 2005 death certificate. They saw Eleanor Holt as the surviving owner. They didn't go back further. They didn't pull the 1979 deed. They assumed a standard succession of title.
They made a loan against the entire property, believing they had secured it completely. An assumption. A crack in the foundation. James Holt, sitting in the library with the law book open, understood. The bank had put a lien on a property based on a faulty premise. They had foreclosed on a property they never had a right to foreclose on in the first place. His father had drawn a line 40 years ago. The bank had just walked right over it.
because they never bothered to look for the pin. James closed the book. He put the deed back in its tube. He had the facts. Now he just had to wait for the right moment to present them. He wasn't going to court. He wasn't hiring a lawyer he couldn't afford. He was going to walk into the last room at the last minute and show them the first thing, the thing they had all missed. He was back in the conference room. The air was thick with tension. James slid the old deed across the table toward the attorney.
Davies picked it up reluctantly, as if it were contaminated. He scanned the text, his eyes moving quickly. He was looking for a flaw, a loophole. He stopped at the signatures, then at the stamped seal. He read the granting clause again. Holt, Frank, and Eleanor Holt, his wife, as tenants by the entirety. He set the paper down. He looked at James. His professional confidence was still there, but a flicker of uncertainty showed in his eyes. Mr. Holt, as I said, this is an old document. Your mother's 2008 loan agreement, in which she pledged the property as collateral, would be considered the governing instrument here. She signed it as the sole owner. She acted as the sole owner. The bank acted in good faith based on her representations. James didn't raise his voice. He didn't need to. He had the truth. It didn't require volume. She did not have the legal capacity to pledge the entire property as collateral, he said, his voice calm and steady.
The tenancy by the entirety was created in 1979. It can only be severed by death, divorce, or mutual agreement. My father's death did not sever it. It fulfilled it, vesting the property solely in my mother. But the protections of the tenancy, specifically against a creditor's unilateral action, remained. She could not pledge what was never fully hers to pledge in that manner. The bank took a lien against her interest, but it could not force a sale of the property itself to satisfy that lien. The words sounded like they came from a lawyer, but they were spoken with the simple clarity of a mechanic explaining why an engine had seized. He had done his homework. He had spent 2 weeks talking to an old, semi-retired property lawyer in the next county, a man who charged him $50 for 2 hours of his time and told him the law was on his side, if he could make them listen. The attorney, Davies, shook his head, a small, dismissive gesture. That's a very creative interpretation, mister.
Holt. But it's just that, an interpretation. We have a court order, a judge's signature. That is not an interpretation. That is a fact. The court order, James replied, his voice still level, was granted based on the evidence the bank presented. Did you present this deed to the court? Davies was silent. Did your title search include a review of all documents recorded against the property since its original platting? Silence. Or did it only go back 20 years, which is standard practice for a refinancing? The attorney's jaw tightened. He knew. At that moment, he knew there was a problem, a deep, foundational problem. James had not come to argue. He had come to state facts. He had laid the cornerstone of his argument. Now he would wait for the other man to see that the building he was standing in had no foundation. The Gables, the young couple, were now looking at Davies with open apprehension.
Their dream house, bought and paid for, was starting to feel like sand shifting under their feet. This was not how the meeting was supposed to go. Davies, seeing he was losing control of the room, shifted his strategy. He leaned forward, adopting a more confidential, man-to-man tone. Mr. Holt, James, let's be practical here. Maybe there's a technicality, a fine point of law that a clever lawyer could argue. I concede that is possible. But the fact remains, your mother owed the bank $9,000. The bank has acted, perhaps imperfectly, but not maliciously. This has been a long and costly process. Dragging it back through the courts will only cost everyone more money. Money, I suspect, your family doesn't have. He was trying a new angle, not law, but economics. The threat was veiled but clear.
You can't afford to fight us. James let the threat hang in the air for a moment. Then he reached into the inside pocket of his coat. He pulled out a single folded sheet of paper.
It was a photocopy, slightly blurry. He pushed it across the table. It slid to a stop next to the 1979 deed. Davies looked at it. It was a page from a book, a copy of a state statute. A single paragraph was highlighted in yellow. James had highlighted it himself at the library. The statute was titled Protection of Property Held as Tenancy by the Entirety. It stated, in dry, unambiguous language, that property held in such a manner could not be subject to levy, execution, or forced sale to satisfy the debt of a single spouse. It was an old law designed to protect families from being made homeless by the debts of one partner, a law the bank's streamlined modern processes had overlooked. "This isn't an interpretation," James said quietly. "It's the law." The attorney read the paragraph. He read it again. The colour drained slightly from his face. This was no longer a fine point. This was a firewall. He looked up from the paper and his polished demeanour was gone. Now there was only a cold, hard anger. He was a man who had been made to look incompetent, and he didn't like it. He tried his last weakest argument, the appeal to authority mixed with a hint of pity. "Mr. Holt, this has all been adjudicated. The time for presenting new evidence was at the hearing. The judge made a ruling. To try and unwind this now, it's just not done. Think of this young couple. They bought the house in good faith. Are you prepared to do this to them?" He gestured toward the Gables, trying to make them allies in his cause. But it was too late. The Gables weren't looking at James with anger. They were looking at Davies with distrust. They were beginning to understand that the bank, not this quiet man, was the source of the problem. James spoke his final words on the matter. The judgment was based on a mistake the bank made when it filed its petition. The bank failed to do its due diligence. That is not my mother's fault, and it is not their fault. He gave a slight nod to the Gables. It is the bank's fault. He said it without malice. It was a simple statement of fact, like saying a wall was out of plumb. That ended it. There were no more arguments to make. The attorney had tried law, he had tried economics, and he had tried emotion. Each had been met with a simple, solid fact. The structure of his case had crumbled. A heavy silence descended on the conference room. It was a silence filled with the weight of unravelling assumptions. The attorney, Davies, stared at the two documents on the table, the 40-year-old deed and the highlighted page of state law. They were like two stones that had been dropped into a still pond, the ripples now reaching the edge. The young couple, the Gables, looked at each other. The husband gave a small, almost imperceptible shake of his head.
Their agent was already discreetly tapping a message into his phone, likely to his own broker, beginning the process of extricating his clients from a deal that was now irrevocably tainted. Davies knew he had only one move left. He could not admit fault, not personally. The institution could be at fault, but he, its representative, had to remain above the fray. He picked up his own phone. He turned slightly away from the table, a gesture meant to create a space of privacy that didn't really exist. His voice was low, clipped. "Get me Carol at the county recorder's office." A pause. "Carol, it's Davies at the bank. I need a lookup, priority. Parcel 7B4, Holt property. Yes, that one. I need you to pull the original microfiche, not the digital summary, the actual film. Look for a filing from 1979, April, a quitclaim deed, Holt Frank as grantor." The room was so quiet they could almost hear the faint, tinny sound of the voice on the other end of the line. Davies listened, his back still to the room. "We see it." He said nothing for a long time. James watched him. He saw the slight slump in the man's shoulders,
the way his knuckles were white where he gripped the phone. Uh-huh. Can you read me the exact language of the vesting clause? Another long pause. The entire transaction, the foreclosure, the auction, the lives of 3 families, all now hinged on the words a woman in a basement office 3 miles away was reading from a flickering screen. Davies closed his eyes. Okay. Thank you, Carol. He hung up the phone without saying goodbye. He turned back to the table. He did not look at the Gables or their agent. He looked directly at James Holt. And for the first time that morning, he seemed to see the man not as a nuisance, but as an equal. The quiet competence of the neutral verifier, the unnamed clerk named Carol, had broken the deadlock. The system, when navigated correctly, had worked.
The truth, buried in a 40-year-old filing, had its own pace. It had finally arrived. The professional mask returned to the attorney's face, but it was a hasty repair. The cracks were visible. He cleared his throat, his voice now stripped of its earlier condescension. "It appears," he said, addressing the room but looking at a point on the wall just over James's head, "there was an oversight in the title report provided to us by our third-party contractor. The bank, therefore, acted on incomplete information." He was careful with his words. Blame was being assigned, but to a nameless, faceless vendor. The institution was protecting itself. He then turned his attention to the Gables. "Mr. and Mrs. Gable, on behalf of the bank, I sincerely apologize for this complication. Needless to say, the sale is void. Our office will be in touch with your agent by the end of the day to arrange for the immediate and full refund of your deposit, along with any associated fees you have incurred." He was efficient, clinical. He was mitigating damage. The Gables looked more relieved than angry. They had been spared from buying a lawsuit. The agent nodded curtly. "Thank you," the husband said. They stood up to leave, a quiet shuffling of chairs and papers. The wife gave a small, sympathetic glance toward James as they walked out. Then the room was empty, save for the 2 men. Davies looked at James. His expression was unreadable. "Mr. Holt, the bank is prepared to offer a resolution. We will, of course, file a motion with the court to vacate the foreclosure judgment. We will clear the $9,000 lien against the property. In exchange for a standard non-disclosure agreement, we can also discuss a cash settlement to compensate your mother for the distress this oversight has caused." It was the institutional solution. A problem had arisen, and the solution was to apply money until the problem went away. They wanted to buy his silence. They wanted to close the file. James looked at the man. He thought of his mother's sleepless nights, of the shame she felt, of the quiet dignity that had been stripped from her by these procedural notices and legal threats. He thought of his father's careful planning, his desire to build something safe and whole. And he knew that money was not the point. It had never been the point. "There's nothing to discuss," James said. His voice was flat, without emotion. He was not negotiating. He was giving instructions. "You will file a motion to vacate the judgment and void the sheriff's sale. You will file a new, corrected deed with the county at the bank's expense, reflecting my mother, Eleanor Holt, as the sole owner, free and clear of the bank's improperly filed lien." A pause. "And you will send a letter to her, an apology, not from a third-party contractor, from the bank." Davies stared at him. The request for an apology was more alien to him than the request for $1 million. "We don't typically—" "The debt," James interrupted, cutting him off cleanly, "is a separate matter. My mother owes the money. She will arrange to pay it, but that will be addressed only after the title to her home is made whole again, properly." He stood his ground on terms, not price. He was not there for a windfall. He was there to restore something crooked to straight.
The attorney, Davies, stood motionless for a long moment. He seemed to be weighing options that were no longer available to him. The quiet authority in James Holt's voice was absolute. There was no room for negotiation. The terms were not a request. They were a statement of what was going to happen. Finally, he gave a single sharp nod. It was the gesture of a man conceding a chess match. He had been outplayed, not through a brilliant, complex strategy, but through a simple, fundamental move he had failed to anticipate. He began to gather his papers, his movements stiff and precise.
He placed them in his leather briefcase, snapping the lock shut with a sharp click.
The sound echoed in the silent room. He did not look at James again. He buttoned his suit jacket, a final piece of professional armor being put back in place. He walked to the door, paused for a second, and left without another word. The door clicked shut behind him, leaving James alone in the grand, empty conference room. He was alone at the polished mahogany table. The silence that remained was different from the tense silence that had filled the room earlier. This was a quiet of resolution, of stillness after a storm. He looked at the two pieces of paper that had changed everything: the brittle yellowed deed from 1979 and the crisp photocopied page of law. He carefully rolled the old deed back into its original shape, his weathered fingers gentle on the fragile paper. He slid it back into the cardboard tube and pressed the plastic cap firmly into place. The document had done its job.
It could rest now.
He folded the photocopy of the statute and put it back in his coat pocket. He didn't smile. He didn't feel a surge of triumph. He felt only a quiet sense of rightness, of a balance restored. He took out the small, worn spiral notebook from his shirt pocket, the one he had used at the library. He opened it to a fresh page. With a stub of a pencil, he wrote a single line in his neat, blocky handwriting. April 11th, 1979. Honored. He looked at the words for a moment. It was a note to himself, a note to his father. He closed the notebook and put it away. He stood up, his chair making a soft scraping sound on the floor. He picked up the cardboard tube. He walked out of the conference room, through the bank's marble lobby, and out into the bright afternoon sun. The auction was over. The sale was undone. The house was safe. Done. 2 weeks later, the morning air was cool and damp. A light mist hung over the fields behind his mother's house.
James Holt stood at the back of the property, at the edge of the woods, his hand resting on a cedar fence post. The wood was grey and weathered, but when he pushed against it, it didn't move. It was solid, rooted deep in the earth. His father had set this post 35 years ago. His mother, Eleanor, came walking across the wet grass to join him. She moved more easily now. The haunted, fearful look in her eyes was gone, replaced by a quiet calm. The bank's letter of apology had arrived 3 days earlier. It was formal and brief, but it was an apology. She kept it on the mantelpiece. She stopped beside him, following his gaze along the straight, clean line of the fence. "Your father would have been proud, James," she said softly. Her hand came to rest on his arm. He didn't say anything for a moment. He just looked at the fence his father had built, the house his father had built, the life his father had built. He thought about the lines on the deed and the lines of this fence. They were the same thing. They were boundaries, meant to protect, meant to last. He said it right the first time, James said, his voice quiet. Just needed to make sure it held. He gave the post one last pat. Some things are planted for the next man. Some lines are drawn for the next generation. A quiet man with an old piece of paper had reminded a powerful institution that the oldest lines are often the strongest. In a system built on assumptions, one person with a verified document can straighten a crooked path. But not all documents are deeds.
Sometimes the proof is not on paper at all. Sometimes it's a photograph, a single, faded photograph from a county fair in 1968. For a woman in rural Ohio, that photo was the only evidence she had against a railroad that claimed a right-of-way it never owned. A right-of-way that would have cut her family's farm in two. We'll see what holds.